So good afternoon. Good afternoon. Welcome. We are really pleased to be here today and to have the possibility to hear from Professor Nea Mishra from the Graduate Institute in Geneva. And we are very grateful with Nea having accepted our invitation to be our guest speaker for the final event of this edition of the Master Program. And I have to say, we have invited Nea for many reasons, but in particular because we, as faculty members, and specifically Oscar Borgogno and myself, we have much enjoyed the book we are going to talk today, that she has actually brilliantly prepared and published, that has to deal with quite an unexplored relationship that is now absolutely central to international trade law. That is to say, the relationship between international trade law and global data governance. So it's absolutely a great area. And so thank you very much indeed for having accepted our invitation. And I would like to thank Dr. Oscar Borgogno, who is working in the research department of the Bank of Italy, and he is also our faculty member, to have organized the meeting. So I've been so kind to organize the meeting, and Oscar will be asking questions and giving input to this debate today. So this is an event co-organized by our master program in international trade law of the University of Turin, but together with the George Washington Center for Competition and Innovation Lab. We are grateful with the George Washington Center for this opportunity to co-organize. Maybe it's the first time we co-organize an event, the two institutions, so it's a great pleasure. And also the Collegio Carlo Alberto, that is a research department, a research foundation in Torino with a focus on economics and also on trade. So it's the best, I think, the best end of our journey during the face-to-face we can hope to have. And I'm particularly proud of it and particularly happy. We will, of course, leave the floor to our guest speaker for a talk, and Oscar will also contribute by providing questions or comments. We will have a Q&A, so you are welcome in asking questions or giving comments or your views about the talk of today, and then we will have our closing ceremony. And we expect to finish at 3 p.m., 3:30 or 4 p.m., just to give you a clear schedule of our afternoon. So the floor goes to Oscar and then to our speaker. Thank you for joining us.
Thank you indeed, Cristina. It's a pleasure to be here and to set up this event together with Collegio Carlo Alberto and the ITC-ILO, the Master in Trade Law, and together with the Competition Innovation Lab at George Washington University. We are glad that we managed to put this together, and we're especially grateful to Nea for being with us today. And again, I'm gonna just have to mention that I'm gonna speak, talking, sharing my own ideas, and in no way what I'm gonna say should be attributed to my own institution, to the Central Bank of Italy. Of course, this is just a disclaimer I have to give you. Now, let's just go to the substance. And Nea, we'd like to talk about your lovely book that came out in 2024. It explored the relationship between international trade law and global data governance. And I'd like to kickstart our conversation by asking you, why should people involved in trade law, in trade policy, should care about data governance at all? Okay. So let's start with this overarching question.
Thank you. Before I start and answer the question, I'd like to also thank the host institutions for having me here, and particularly Professor Cristina and Dr. Oscar for getting me here, Mario for organizing everything, and all the students for being here. And I'm so delighted that I'm a small part of your beautiful journey. So thank you very much for having me here in a very beautiful city as well. So to answer your question, Oscar, when I started working on this book, and much before the book, researching on this area, trade law and data governance were often seen as two separate things which had nothing to do with each other. Most of you have studied a lot of trade law, so you know it's all about what treaties are there, what is the WTO doing, what are regional bodies doing. While data governance was a lot more distributed, it was not very clear where the action was happening. Was it at the national level? Was it at an international level, at a global level? Were there some transnational policy networks around that? So it was a very interesting interface to bring together. And the starting point for my query was looking at a lot of measures that were restricting cross-border data flows, because that went to the heart of trade. Because for most of you who are familiar, and even if you're not familiar, sometimes unconsciously you are part of this whole global supply chain where data is constantly flowing across borders, and that's the basis on which a lot of transactions, and not just economic transactions, but also social interactions that we engage in are happening. And because cross-border data flows are so much at the heart of the entire economy, I started getting curious. So if there are certain policy risks because of which governments are regulating cross-border data flows, what kind of impact does it have on trade? Is it restricting digital trade? What kind of trade agreements are potentially breached? And that was my starting point of query. But then I started landing up in very interesting territory, which is basically, and I think there's a lot of discussion around this these days, is when governments start to regulate data flows, they frame certain narratives. And at that time, when I just started, and I think over the years this has become much more solid, is that there are two ends. One is this free internet space, free flow of data, and the other end is a data sovereignty, digital sovereignty, restrictive internet. And you had this impression that certain governments were supporters of a free internet and certain other governments were trying to impose these ideas of digital or data sovereignty. But what I realized in practice was that it was not so black and white. Most governments have shades of gray in the sense that they might support free flow of data, but they might also restrict cross-border data flows for different policy reasons. And that all creates a very interesting regulatory framework and also fragmentation in the way we look at it globally. And that kind of inspired me to look at it from a trade law angle. One of the first things I mention in the book is that when you have two extreme narratives, then you start having narratives which try to navigate the extremes. And that's where the idea of data free flow with trust, which I know you have also been working with in OECD, came about. And that's something that also informed me in thinking about what the role of trade law could be. So essentially, then I started looking at two aspects of the interface, which I think are very critical in trying to understand this relationship between trade law and data governance. One aspect, which is what, as trade lawyers, many of you will be familiar with, which is that if there are restrictions on cross-border data flows, then certain treaty provisions might be violated. You can apply trade rules. In practice, and maybe we can discuss this later, the applications can be quite complicated because the questions that arise might go in very different directions and may not even be very trade law specific. But the other element which I wanted to highlight through the book was just the fact that we are missing one part of the picture where trade law can be a building block in this global regulatory framework. And therefore, I explore many ways in which trade law can also contribute to creating more resilience, more robustness, and more regulatory certainty in this entire framework for cross-border data flows. So those were the two starting points for my query.
Thank you. Thank you, Mira. Indeed, as you said, I had the privilege to work at the OECD within the Italian delegation on the Data Free Flow with Trust initiative that has been taking stage since the Japan presidency of G7 a few years ago decided to strongly push for that, and many other countries decided to follow on. And indeed, the narrative at the time was to open up as much as possible digital trade in order to make sure that each country can make the most out of digital trade. And of course, data flows were at the very building block of such narrative and of all the policies that were trying to be shaped and developed at the OECD stage. But now, staying a little bit again on trade law. I'd like to ask you. In your book, you tackle many different aspects of data governance when it comes to international trade, but what about existing trade laws? How do they apply to the current global data governance framework? And you started your analysis by the status quo, and I'd like you to delve a little bit more on these.
Yeah. So thank you, Oscar. Actually, when I started looking, I realized a lot of people were, and I remember it was almost a decade ago when I started looking at cross-border data flows and how data regulation is happening on the ground. And I remember at that time I had proposed, I was a master's student just like all of you, and I had proposed a thesis on writing a thesis on data localization and how it can breach trade laws. And I remember there was a classmate of mine who used to work at the Ministry of Trade of a particular country. He looked at me, he said, what does data localization have to do with trade law? So the starting point was that of a lot of skepticism, but as I went into the topic, I actually realized there are different aspects of trade law that can be relevant. And currently, if you look at the existing framework, there are 3 sets of treaties, I would say, which are very relevant. The first one is WTO treaties, and most of you are familiar with it. In particular, the General Agreement on Trade and Services, or what is called the GATS, typically is considered quite relevant because when you think of data, it is like an intangible entity. It's like a service, so it often gets classified under the GATS framework as a service. But there are things to think about where how it can also, there can potentially be some interface between GATT, which is the Agreement on Trade and Goods, and the GATS, which is on services. In addition to that, there are 2 new kids on the block, I would say. The first one is free trade agreements or preferential trade agreements, and it started in 2000 when there were few preferential trade agreements which had e-commerce chapters, but if you have been tracking it, there are now many, many agreements, and Professor Meera Bari and her team actually have created a very good database at the University of Lucerne. So if you are interested in this area, you can actually look at that database and see how the treaties have been evolving.
The TAPE database,
yeah, the
right?
TAPE database, if you're interested, do take a look at it. And then there are digital economy agreements, which are actually not like conventional trade agreements. They only look at the digital trade or the digital economy aspect of this entire framework. Now, because you are trade law students, I think I will exploit the opportunity and go a little bit into technical details here. Now, typically when you look at a data restrictive measure, data localization is often a very commonly discussed measure. The first step, as you know, is to see what kind of obligations might be breached. So let's say if you're looking at non-discrimination principles, let's say a country decides to ban a technology from China. That could be a breach of most favored nation treatment. It's, of course, as you know, as trade law students, the analysis can get more complex in practice, but that's an example, at a high level, that's an example to think about. Or, for instance, when there are data localization measures, which are very widespread now across the world, they can breach, for instance, principles on national treatment, because essentially it might be much more expensive for foreign companies to establish local data centers, and that can also create a lot of compliance costs, and as a result of it, domestic firms might actually benefit. There are other things like domestic regulation. So you might not have something on paper that looks discriminatory, but maybe you have a licensing mechanism which is implemented in a very arbitrary manner in certain high-tech sectors. Again, that could be a breach of trade law.
Well, and just for the sake of our students, could you clarify what do you mean by data localization? Because there's a lot of controversy on that as well. So.
Yeah, that could also be something worth discussing. So I think there are different ways in which people look at data localization. The simplistic way is that if a country requires you to, so let's say you are Google and you're operating in, let's say you're operating in Ghana. The Ghanaian government could say, hey Google, you're free to function in our country, you're free to provide your services, but all that data you're collecting from our people has to be stored within our country in local servers. So that could be a very simplistic form of data localization, but it could take other forms as well. So for instance, you could say, well, not the data has to be stored locally, but also processed locally. So what is common is a lot of times companies might store data locally, but during the time of processing, they might take it to another server because that's how their global operations work. So it could also extend to processing of data. There have been some instances where, not very successfully, where governments have said not only should you store and process locally, but even the data routing should be only within the domestic networks within the country. So essentially, if I'm sending an email to Oscar, it should not be routed through a server in, let's say, Singapore. It should, if we are both in Italy, it should be routed through a server in Italy. So that would be a very extreme, it's not a very successful model, but this is also something that some governments have at least tried to advocate for, mostly on national security grounds. So that's kind of, again, a multi-layered concept. Russian government, they had a concept of data localization in their data protection law, where they said, well, actually you can store abroad, but we need a copy of that data to be stored within the country. And that was perhaps also about surveillance, because if the data is stored within the country, it's easier to keep track and know where it's stored and regulate it. So that's one aspect, the obligations aspect. Also market access. So for instance, if you're going to ban facial recognition technology, and again, trade law students know it's complex because you have to look at what kind of commitments have been made, but it could technically, again, violate obligations on market access. Now with FTAs, there are some more specific rules on data localization and cross-border data flows. So it becomes even more certain that you have to actually, if you are imposing a data localization measure, and that is restricting digital trade, then you could be breaching violations. Now, the good thing about trade law is it offers exceptions, and rightly so, because there are lots of good reasons why countries might want to restrict cross-border data flows. And I think most trade law students know that the exceptions are a bundle of joy, but also a bundle of mystery. So you have the general exceptions, the security exceptions, and within free trade agreements, you also have these exceptions which are more broadly worded. They refer to legitimate public policy objectives. And all of this entails a very complex weighing and balancing exercise of different factors. And one point I would mention here as lawyers is it's very interesting, because once you start getting deeper into these questions, you realize they are not only questions of trade law, but they are also questions about data regulation. For instance, what cybersecurity standards are the most robust form of standards? Or is it only possible to enable privacy by restricting cross-border transfer of personal data? Can it be done in some other manner which is equally good? Or it could be, if a government wants access to data, is it necessary to impose data localization? What if the company commits to provide access to data anyway, irrespective of where it's stored? So these questions then start going into a very different domain, which is not really trade law, but the questions might still arise before trade bodies, and that creates more confusion. And this is something I think future trade lawyers might have to deal with a lot more than the past generations have.
Yes, indeed. I mean, listening what you said, it seems to me that actually a lot of the problem relating to digital trade law comes from the fact that each country is trying to reaffirm its own sovereignty in the digital space, and by doing that, they will start most of the time trying to apply, the good old methods that used to function for trading goods. But it might not be the case, right, for digital services and data flows, because it's so difficult, to restrict information flowing around across borders. And the fascinating aspects of digital trade is really about all this game, this back and forth between national sovereignty and countries trying to reaffirm it, and and the inherent nature of the digital economy, which by definition escapes national borders. But now, going back to a point you touch upon, which is cybersecurity, I was thinking about the whole multidimensional aspects of global data governance that you brilliantly covered in your book. And there are many chapters relating to the different angles. We call it in an article that I wrote with a colleague of mine, the triangle of data governance, because actually we pointed out that data governance, it should not be considered as a subject on its own. I mean, you can argue against our thesis, of course, if you want, but basically we just found out that there are many layers that goes to build up data governance, and one of them might be national security, another one is personal data protection or privacy, and another one is competition and competition concerns. And they might not go in the same direction. This is why the overall picture is so complicated. So I'd like you to delve a little bit more on these issues, on the multidimensional aspects of data governance, and we might just start with the main pillar, which is personal data protection. How did you find out that personal data protection relates to trade laws and to global data governance overall?
Yeah. So I think being here in the EU, most of you are familiar with the GDPR. There's a lot of discussion about it. And data protection laws are growing all over the world. You can say EU has been a big influencer in that regard. And if you are a little familiar with data protection law of any country, you'll know it's a very complex framework for collection, processing, and transfer of personal data. And as I said, data is constantly being transferred across borders in all kinds of, even your TikTok videos, all of it is data transfer. So if you think you're away, I'm not affected by it, this is all about trade, you're very much a consumer in digital trade. We are all engaged in digital trade, whether we know it or not. So particularly for data protection then, so as I said, there's a lot of increasing regulatory activity on data protection front. Different countries are implementing data protection laws. They're often on the grounds of privacy protection. For instance, in GDPR, you'll often hear the narrative, one of the biggest goals is privacy protection, but it could be interconnected with other policy objectives as well. So for instance, GDPR is also about creating a single market. Or if you look at other countries, so for instance, in China, a large part of their focus of their data protection law is also about information security, which may not seem so intuitive, but that's how the law is structured. In some countries, data protection law is seen more as a consumer protection law. So it comes with, again, it's multicolored. Different countries, as you said, different countries exercise their sovereignty to look at data protection very differently, because of which we don't have much global consensus on what the golden benchmark is. Often people say GDPR is the benchmark, but a lot of other countries across the world do not necessarily agree with it. It's also a question worth thinking whether the culture of privacy and data protection that the GDPR supports is suitable for every country across the world. Then there are other frameworks such as the OECD has its privacy guidelines, APEC region, they have their own privacy framework, there's the COE convention. So there's a lot of things on the ground, but that also means there's a lot of regulatory fragmentation. And one of the main areas where you see this is with respect to transfer of personal data. So as I said, if you are using anything online, your personal data is being collected and probably being transferred across the border. But if you are in EU, for instance, it can only be transferred to certain countries or under certain safeguards, where certain safeguards are available. And that's often called the adequacy mechanism, or if there are specific safeguards available, you can specifically look at that. Other countries don't follow this model. They might have an accountability-based model where companies can transfer data as they like, provided they comply with all the data protection principles that are embedded within the domestic legal framework. There are other countries where the data protection law might have data localization, sometimes for all kinds of personal data, sometimes for sensitive categories of personal data. There are some countries where you might have some ad hoc regulatory approval mechanisms. So all of this, when you start putting all this together and think you are a global business, forget about that. Think you are a small business, you are an entrepreneur and you want to start a global business. This is what you have to navigate. The EU has a set of requirements, the US something else, Australia something else, India something else. And that is what basically, that kind of regulatory fragmentation is what creates a barrier to trade as well. Of course, you can look at specific examples, and GDPR particularly is heavily discussed. So for instance, whether the adequacy framework under the GDPR, which is only available to a set group of countries, could violate principles of non-discrimination. And if so, can you justify it under the exceptions? And because this has been a point of legal uncertainty, a lot of recent EU free trade agreements really create a huge carve-out for privacy, so that privacy measures, when implemented by countries, cannot be challenged before a trade tribunal. Another point of divergence I'll note is between WTO and FTAs here. So WTO is a very much pre-digital era treaty. There is no specific requirement that all WTO members should have a data protection law. However, the exception, the general one clause of the general exception might apply if you can show that a particular measure is necessary to achieve compliance with data protection laws, which are meant to protect privacy, for instance. But free trade agreements, a lot of new generation free trade agreements actually have clauses on data protection, which require countries to adopt a basic minimum framework for data protection. Of course, in the EU framework, those become much more stringent. A lot of the US-based FTAs or Asian-based FTAs tend to have more lenient framework as to what is enough to be considered a framework for personal data protection. But all in all, this again creates all kinds of legal and regulatory uncertainty and also business uncertainty. And that's what I wanted to kind of bring out through the book as well, because this is also a big challenge for trade law. Whether it's regional trade agreements, free trade agreements, or WTO law, there's this constant tension whether a country can implement a data protection law. If so, is it able to do so within the existing trade framework? Will it breach certain trade rules? And if it does, can it be justified under the exceptions? And that kind of creates a lot of complexity in this space.
Yes, indeed, because once you have legal heterogeneity when it comes to personal data protection, one thing you want to do if you put yourself in the shoes of a trade diplomat is to reach some form of harmonization between different jurisdictions in order to make sure that such frictions are as much as possible curbed down. But it's not that easy, right? And we might even ask ourselves, what are the boundaries of trade law? I mean, should trade law be allowed to get priority over other legal bodies such as data protection, which go really at the core of what many jurisdictions feel as their own sovereignty, power. And this is for sure the case of European Union, where personal data protection really reflects fundamental rights protection. And moving to another field of data governance, let's talk now about competition law, how it relates to data governance and what's the impact on trade. Because again, talking about Europe, we have seen a lot of investigation carried out by antitrust authorities, both at the national level and at the European Commission level, about how big companies holding market power, dominance in digital markets, are basically abusing their power, their dominant position by leveraging data from users, by putting together data coming from different sources in order to build up super profile about their users, and thereby exploiting them somehow. At least this is the narrative pursued by many antitrust authorities. And on the other side of the bench, large technology companies complain that this might amount to some form of protectionism carried out by European countries, or by the way, by any other countries, enforcing antitrust laws in a way that is basically looking at how data practices have been exploited by market powers. By companies holding market power. So what's your take on this? What's your take about the relationship between competition law and trade law when it comes to data governance?
Thank you. I should say, you mentioned about, when there are different regulatory frameworks, governments, and especially the people who sit on the as trade negotiators, try to achieve harmonization. I think the new buzzword has also become interoperability, because what governments have realized is no one wants to compromise on their sovereignty. So they are now trying to figure out, okay, we are all going to do what we want, but we'll do it in an interoperable manner. I think a question for the future generation is also, what the hell is interoperability, and how do we implement it in practice? With regard to competition, I think, again, I realize a lot of students are very familiar with competition law questions as well. Specific to the digital sector, there has been a lot of activity on the competition or antitrust law front. And there's, as you said, a lot of concern because big tech companies are seen as data monopolies, and that has its own impact. For instance, creating these giant network economies of scale, market tipping. Once a company has that kind of data, they can enter as many adjacent markets as they want. So you can see Google has all kinds of services, not just their core search engine. And they often stifle new entrants because it's just very hard for a new entrant to break into these markets. However, economic evidence is not always so clear. So the instinctive reaction of many competition regulators has been to come down more heavily on big tech companies. They have created new frameworks on, let's say, data portability, data interoperability. In some countries, like they have started creating mandatory data sharing requirements, including in the EU, in India as well. But it's not so clear. The economic evidence is, as you said, not so clear whether all of this is harmful for innovation or whether putting this will actually create a level playing field and create better, stronger, more competitive markets, because digital markets are also quite unique in their own way, and which makes them again very different from traditional markets. Now, what I found was that a lot of these competition law concerns also played out in the trade space, because not only was it could be considered as a form of trade protectionism, an allegation that the United States governments, for instance, has constantly made against the EU for a lot of different antitrust action that has happened over the years. But it also genuinely affects the business model of many companies. For instance, with regard to data interoperability, even after data interoperability requirements were put in place, one study showed that actually very few companies were actually taking advantage of it. It was just something which existed on paper, and it was a compliance check or a compliance burden, depending on whose perspective you're looking at it. But it wasn't actually generating new business, or it wasn't generating new market opportunities. So there's a lot of uncertainty. Also, another factor I would mention here is that if there is over-enforcement of competition law or selective enforcement of competition law, let's say you want to target specifically very, very strong players like maybe from the US or from China, then it also creates geopolitical tension. So all in all, it's not a very happy space in that regard. Now, with regard to trade bodies itself, now I think again some of you might have studied this in your trade law, WTO law course, which is that role of competition in WTO has always been a little bit of contested space. And it has been contested both by developed and developing countries. It's not just developing countries or not just developed countries. And the EU has been the biggest proponent.
But with different arguments.
But with very different arguments, of course, because for developed countries, particularly for the US, the stance has been, look, we should deal with these issues bilaterally. This trade, WTO is not the place for it. And for a lot of developing countries, this has been a question of policy space, particularly after the TRIPS agreement. They are very scared that they will be giving up a lot of policy space, and they will not be able to regulate their domestic market. And with the digital economy, the concern is they might not be able to adopt industrial policies to promote their own digital sector. So it has always been a very controversial space. So this is actually the least optimistic area for me at the multilateral level. But I do still think there are possibilities of having more coordination in regional trade agreements or in digital economy agreements, which tend to be between like-minded partners. And so far, competition disciplines in free trade agreements have been quite light, except in the context of EU, who, again, because of their competition culture, they have always had more comprehensive chapters on competition, but they have generally been very silent on digital competition in the digital sector. So there is a possibility of agreeing at least on high-level principles, but I'm not so optimistic about it at the multilateral level in the immediate short run. Perhaps in the medium to long run, that's a possibility.
Yeah, fair enough. It makes completely sense to me as well. And now looking at another aspect of global data governance, I mean, in particular in these times of geopolitical tensions, one aspect we cannot avoid is national security. You mentioned China that when it comes to data governance really cares about overall national security. What about if the data of millions of people in my own jurisdiction get breached and just get downloaded by external, maybe adversarial players in other jurisdictions beyond my own reach? What about that? This might be a national security issue. It's not about protecting fundamental rights. And nowadays, many other jurisdictions are grappling with the same problem. And so I know that you consider also the national security and cybersecurity angle, we can also say, of data governance. So what about this aspect? Do you see any prospects that international trade law can tackle these, or overall international coordination may just contribute to achieve some form of harmonization in the way in which countries use the exception of national security in order to pose barriers to digital trade?
You're right. I think it was it came from the Chinese government for the first time that cybersecurity is a form of national security. I have to say, a decade later, every country believes that. So the narrative has really changed. So people who have studied cyber law will know that cybersecurity was actually very much defined from a very computational science angle, that it's about confidentiality, integrity, and authenticity of data and the networks that carry the data. And today, when you look at the cybersecurity narrative that's discussed in trade fora, the technical angle still, of course, exists, but to that there are all these different layers of politics, geopolitics, even economic security has now become a fundamental component of this. And so again, at the global, it's a little bit like the data protection angle. At the global level, there are lots of things, but they're all kind of fragmented and distributed. So some of you might know there's something called the Budapest Convention, which on cybercrime, which signed about 68 countries now, but again, it is often seen as a EU thing, so a lot of other non-EU countries don't really subscribe to it, and also it is just about cybercrime, which is an angle but doesn't cover the entire dimension of cybersecurity. At the UN, there have been other discussions. There's something known as the GG, and now there's still an ongoing open-ended working group which discusses cybersecurity and certain norms in international law that apply to cyberspace. You have a new cybercrime treaty being discussed at the UN. Then you have other international organizations, some which are even looking at capacity building in cybersecurity. And then you have the private bodies, the Standard Development Organization, who actually are producing these standards and implementing these standards. Often they are forgotten in the picture, but they are actually the ones who hold the keys to cybersecurity. And it's quite interesting because all of this now gets connected to national security, which means that countries become a lot more conscious when they are making even commitments in trade agreements in relation to data flows, because they think this is a question of national security. Should I be willing to make those commitments? And what we have seen in the recent years is that certain governments have either refused to sign trade, like digital trade chapters, very extensive digital trade or e-commerce chapters, because they think it's going to breach their policy space. Or you have certain treaties. One example, for instance, is the RCEP, which is from the Asian region, the Regional Comprehensive Economic Partnership Agreement, where the RCEP agreement has an e-commerce chapter, but with very broad security exceptions, which essentially allow countries a lot of space to determine what is essential security concern and how they should be able to regulate those concerns. So all in all, it creates a very tricky picture, right? Because on the one hand, these exceptions the exceptions, and this is the WTO law students again know this, that the exceptions contained in WTO treaty actually apply in very exceptional circumstances, where, for instance, there's a war ongoing between nations, or where it's related to military or nuclear facilities. It doesn't apply to like day-to-day things like this country is an adversary and therefore I don't want data to be transferred to that country. It's not something that's covered by the security exception. It's also important to remember the technological infrastructure, which is that security is not always a function of geography, it's a function of technology. You might have all your data stored within the servers in your country, but that could still be hacked and targeted. So if you don't have the right technological framework, sometimes data localization is more harmful than useful to protect security of that data. So it's worth thinking, then it kind of creates a complex picture. Add to that the data access issues which you raised as well. So a lot of governments now think, and you might realize a lot of criminal activity now happens online. So governments want immediate access to data, and of course there can be things like mutual legal assistance treaties, which are very slow and don't work properly in the digital context, because it can take months before you actually get access to data. So if you're investigating an online hate crime, you want immediate access to data, and that has become another ground why countries want to impose data localization measures. And then again, you land up in the same soup where you're basically trying to, on the one hand, promote digital trade, but on the other hand, you have all these concerns which make you restrictive of digital trade. Now, in terms of what the response has been, WTO law, of course, doesn't have any specific provisions or any specific things on cybersecurity. Some of the rules in WTO law still apply. Even the TBT agreement, for instance, if you're looking at goods and cybersecurity standards, that could be relevant. But another new development has been now free trade agreements tend to have more clauses around cybersecurity, often softer provisions on cybersecurity cooperation, but you also see some change happening. So for instance, digital economy agreements now have started adopting a more multi-stakeholder approach to online security, because they realize there are many actors involved and many dimensions involved to this. So overall, it's a complex picture. With data access, one of the developments has been at the OECD, where they have developed a OECD declaration on data access, which basically lists out the basic principles that are necessary to allow governments to exchange, to share data with other countries if there are concerns around online crime or some kind of regulatory access to data is important, let's say by a financial regulator or in other critical sectors of the economy. But within the trade law framework, these things don't get showcased as much. And one of the proposals I make is that it's time for us to think more carefully whether some of these emerging frameworks outside trade law could be incorporated by reference within the future rules that we are going to see in this space, because it would solve one of the biggest problems, which is genuine concerns around regulatory access to data, while also ensuring that it doesn't unnecessarily disrupt digital trade flows. A very good example in this regard is the US Canada-Mexico agreement. In their financial services chapter, they have a clause which says that, well, we agree not to impose data localization, but if a regulator needs access to data for XYZ reasons, legitimate policy reasons, then they will be provided immediate access to data. It doesn't matter where that data is stored.
From each other jurisdictions?
Yes, okay. So it doesn't matter. So if, let's say, the financial regulator in the US wants access to certain data and it is allowed by the legal framework of the country, even if that particular financial services provider is based in Mexico, they are still going to provide that data if it is already provided by the legal framework of the United States. So that kind of is a positive development as well in the trade space.
Yes, it is. It is. And indeed, while we're talking, it became apparent to me how these different components of data governance, data protection, national security, competition policy, they don't just interact with the overall framework of data governance, but they do interplay between each other. Depending on how you interpret the government mandate when it comes to protecting national security and getting access to personal data, not just in your jurisdiction, but all over the world, then this impact, the cross-border data flows under data protection laws between different jurisdictions. And this was exactly the case that happened with the adequacy decisions of the European Commission that authorized free flow of data between United States and Europe, and they were then basically wiped out by the Court of Justice because the United States government, based on national security concerns, basically authorized within its own jurisdiction very broad access to information held by private companies. And this poses a very tricky problem to solve.
Yeah.
And indeed, we're still grappling with this solution because then European Union needs to really trust how United States and companies based in the United States are safeguarding data and information belonging to European citizens. And this is really key. And you explored this really fascinatingly in your own book. But now, as we approach the final part of our conversation, let's really delve into the suggestions or the proposals you put forward in your book. And I'd like to know a little bit more about your take on the role of multilateralism when it comes to achieving a better global data governance frameworks that can actually serve digital trade. And we have plenty of international organizations that work in the sphere, in the area of international trade. We already mentioned the OECD, we mentioned the WTO, and there are many others that work on that. Now the Financial Stability Board, together with the OECD, the FATF, are trying to, to cooperate in order to solve or to create a minimum level of harmonization when it comes to personal data protection and cross-border payments, because now also financial international organizations understood that depending on how data protection laws are implemented, whether in a harmonized way or in a heterogeneous way, it really matters for how cross-border payments take place between different jurisdictions. And so this is a matter not just for people in data protection, but also people in financial regulation. So based on your own studies, on your own research, what's your take about what multilateralism can realistically achieve in this field?
I have to caution though, when I wrote the book, things were looking a little brighter in the world. Today maybe they look a little less brighter, but generally speaking, I do firmly believe that multilateralism has a role to play and will continue to play irrespective of what kind of politics we see in the world. There'll be ups and downs, but it will continue to be an important driver. So in terms of thinking about the proposals, as I said, one of my ideas was that the international trade law should not just be about what are the restrictions and how can we look at it if there's a dispute, what rules will apply, how will the exceptions apply, but it should also be a building block of this global digital economy. And in that regard, I framed a lot of proposals keeping that idea at the back of my mind. So there are a couple of things I suggest in the book, and some of them are more realistic, I think, in the short run, and some of them less realistic. What I've called the approach in the book is a multi-layered approach, and I think that essentially means that we have to look at it from different angles and involving institutions at different levels of governance, and also involving not just developed countries but also developing countries, which is another big set of questions because it opens up very difficult questions around how to bridge the digital divide and how to boost digital development. But I'm going to kind of outline this multi-layered framework, which is the existing treaty provisions, much of which can actually be meaningful, and people forget some of the very useful provisions in the WTO framework, things around transparency of regulations. Currently, one of the biggest problems is countries don't know how these digital and data regulations are going to be implemented, and there's very simple provisions on transparency, if implemented in good spirit and with good faith, can really make a huge difference in creating certainty, legal certainty, and more coherence within the international legal framework. Similarly, there are many mechanisms at the WTO. There are different committees which keep discussing these different issues. Even simple things like mapping, let's say the cybersecurity space. We know that a lot of countries want to implement cybersecurity measures.
mapping them, tracking what's going on, trying to create a catalog of those measures can create more policy certainty. Another proposal, for instance, which I have, which is more on the soft law side, which is to just have a declaration by maybe a smaller group of WTO members, maybe something like under the plurilateral initiative. Some of you might know at the WTO currently there's a plurilateral initiative which is called the Joint Statement Initiative. Even a non-binding declaration can be an important guideline for countries to figure out how to implement their data regulatory frameworks. So these are not very high ambition things that I propose in the book. There are others which I propose which are a lot more ambitious. One of which is to try and bring the multilateral framework closer to the multi-stakeholder framework, which is something that is currently completely missing in the dialogues. Because if you think of these different aspects of data governance, data protection, cybersecurity, data competition, you have a lot of transnational regulators in this space. So competition, you have the International Competition Network. In privacy, you have the Global Privacy Assembly. OECD is not technically, it is a grouping of countries. It's not the entire world, but they are doing a lot of important work. Now in Africa, there's the Digital Trade Protocol, and they might be doing a lot of important work. The ASEAN has been doing a lot of important work in trying to create e-commerce frameworks in that region. There have also been discussions around how to create more interoperability between the let's say, the APEC frameworks and the more EU-based frameworks. So that's the other level where multilateralism needs to talk to these other, bodies which are not necessarily within the multilateral framework. And also in addition to that, you have, when you think of the technical infrastructure, the internet, you have standard setting organization, you have internet technical bodies. So those of you who are familiar with internet governance space, it's very multi-stakeholder. It's not like there's one central authority that decides what all the technical protocols should be. It is decided through a very multi-stakeholder process. And I think that is the bigger challenge in the long run, to bring the multi-stakeholder and the multilateral workings together. But that, I think, is a sustainable way forward, especially in the digital economy space, because there are many different building blocks, and the only way to create more coherence between these building blocks is to kind of bring them together. And therefore, a lot of proposals that I make across the chapters is really about figuring out and building more bridges between these different disciplines instead of trying to operate in a siloed manner.
Yes. Yes. And when you say multi-stakeholder approach, do you just mean different regional initiatives among, jurisdictions, or you also want to allow at the table private actors? I mean, companies or firms, because there might be risks as well as opportunities in doing that. And what's your take on this?
I mean, arguably, I think even today, the way structures work in many trade forums, companies do get a voice through their own government, because they can make representations to their government, and the government then takes into account different stakeholder views before they make a negotiating position at the WTO or some other regional body. So in that sense, I think it's already there to some extent, but it was more, my idea was more in the context of, for instance, things like standard setting, which is actually a very core issue, which does not really get that kind of attention within the trade law context. And if you remember, I said in the cybersecurity context, governments can come up with all these regulations and complex frameworks, but ultimately the ones who are designing those standards and implementing those standards are private bodies. And therefore, it is much better to create more networks that allow these different communities to speak to each other than completely isolate them from each other. So one of my suggestions, for instance, would be that, let's say, the internet governance bodies and the trade framework, whether it's at the WTO or at more regional levels, have more interaction with each other to figure out, because there are a lot of aspects of digital trade which have very much to do with internet governance. Soon they'll have to do a lot with AI governance. And that's the reason why I think multilateralism, I think it's just a different kind of multilateralism, and which is suited to the realities of the world and also of the technology that we are dealing with.
Wow. I will not be in the shoe. I would not like to be in the shoes of a trade negotiators nowadays, because I mean, I think that job of this kind has become extremely more complex than it used to be in the past, when you have to deal, you know, with old-fashioned tariffs and trading goods, and that's
tariffs
it.
are back in the game, though.
Yes. But when it comes to digital trade, tariffs to digital trade, I mean, that's hell of a problem, I believe.
No, I think to have tariffs in digital trade, you would have to breach a lot of privacy, because you'll have to track everything that comes in and out to make it convert it
Indeed.
into a
Just to
tax.
enforce them will be a problem on its own. Yes. And one last question before we can open the floor to our audience. I mean, nowadays the talk of the moment is about artificial intelligence, and data governance really relates to artificial intelligence, because, you know, the main input of big AI foundation models is data, because data is used to train AI models. Of course, we do have chips and chip value chains, but then we do need information in order to make sure that foundation models and secondary training of foundation models really make sense and is able to solve our problems. And then I'd like to know a little bit more whether you consider, maybe not in the book because it's very timely and it was not the talk of the day in 2024, but how AI nationalism, again, that has been described by many scholars at this point, by which I mean how different jurisdictions are trying to push forward AI industry and AI development within their own jurisdiction, interact with global data governance, and might pose an additional hindrance, you know, to global digital trade.
That's a fantastic question. So I think perhaps it might have already been quite clear for me, this dichotomy between, you know, completely liberating data and completely restricting data is not a helpful dichotomy. It is the most unhelpful dichotomy you can have. And the language that I use in the book in the context of freeing up data flows and making sure we have a trusted framework of data flows is to build more structures of cooperation, of regulatory alignment, and also digital inclusion, which is an element which we didn't discuss, but it's also an element that I bring together. Now, when we take this to the AI space, some of you might know that there are now more rules which are dealing with AI-specific issues in recent free trade agreements and digital economy agreements. So, for instance, one provision that has found space is on AI ethics. It's a very high-level provisions where countries are agreeing to adopt certain AI ethics frameworks. The OECD AI ethics frameworks are in particular very popular as a reference point. There are also more provisions which deal with algorithmic disclosure. So for instance, you might know that a lot of governments now want to audit AI, and for those purposes, they demand access to source code and algorithms. But many trade agreements contain provisions that prohibit access to source code, because the concern is that if if the government can have access to source code and other vital technical information of foreign companies, they're going to pass it on to domestic competitors. And this was something that actually the US government first pushed in what used to be the TPP agreement, because they were concerned about Chinese companies just replicating US technologies by getting access to that vital technical information. But I think now we are reaching a stage where AI is a lot more prevalent. So the questions have also, one is around development of AI, and one of the biggest arguments that's being made right now, particularly by people who look at it from a global public good perspective, is that AI fragmentation or AI nationalism is actually very bad for AI innovation, because you need global data sets to be able to build the best kind of AI. And in the absence of that, what might happen is that you might have artificial intelligence technologies which are built by certain digital powers, which are trained on certain kind of data that comes from those digital powers, and which, when implemented or used in many developing or countries or LDCs countries, LDCs might be completely out of context, might malfunction and create all kinds of social and risks, social and political risks to those societies. So when you look at that narrative, then AI nationalism seems like a very narrow-minded, short-term goal, because it doesn't really achieve anything. The other element, I think, also which I feel there is more growing consensus on this is that a lot of these policy concerns around regulating AI are really transnational policy concerns. Even if you look at basic things like data protection, even European Commission being such a successful data protection, a center of data protection, has not been able to actually always enforce GDPR very effectively in practice. And many people in fact think it's just a tax on SMEs because the big companies have figured out their ways of dealing with GDPR. So if we want to actually create a competitive space in this AI markets and have more innovative ideas, AI nationalism is also very harmful from that perspective. So therefore, I think, again, the message in the book, although I didn't really specifically think about AI technologies, but that thinking about it in terms of what is the added value on finding consensus and regulatory alignment, would still counter those forces of AI nationalism in the coming years. But it's hard also because the geopolitics of AI is very strong at the moment, and also very divided at the moment. But I think AI scholarship in general is acknowledging that it is not conducive to building robust and beneficial AI technologies.
Yeah. That's great. Thank you so much. And at this point, we can open up the floor to our audience if you do have questions. While we're waiting, I will ask you one more final question on this. We do have a question, so
the usual suspect, Yemi.
Yeah, please.
I know they have a celebration coming up, so I will not stand too much in the way.
Yeah, very quickly. Just present yourself and then ask your question. Yeah.
Hi, my name is Yemi Bello. In the LLM cohorts. We looked at 3 components of global data governance, personal data privacy, competition, national security. I wonder if there's room for one more component, and that's taxation. I ask because, not just because I'm working on that topic, but also because I see multiple parallels. We've spoken of fragmentation and multilateralism. I'm aware that the OECD is working on a multilateral approach to international taxation of digital services. But I'm also aware that Canada, where I work, where I live and practice, is also has a digital services tax act, which is the subject of my research. I also hear some bits of the open debate whether taxation is whether tariffs, a tariff is a tax, as well as whether taxes such as digital services taxes are comparable to tariffs and what the implications of that could be.
Thank you.
So back to my question, is there room for taxation in that framework, and what are the broad issues and insights that you might have on that?
Thank you. I think the question is clear, and the room is yours.
Okay. So yes, taxation, 100% with you. I think taxation is also a missing component in my book. I'm pretty sure in one of my footnotes I would have said I'm excluding taxation from the scope of this book, specifically because I'm not a tax lawyer, and secondly, I'm very scared of tax. It really is very complex, and but it is true that taxation has also become a very big part of this narrative and discussion, and I think at OECD as well there has been a lot of discussion. And even at the WTO, specifically to the e-commerce moratorium, I don't know if you're familiar with the moratorium on e-commerce, but there is a instrument which different WTO members have been signing for a long period of time, in which they agree to not impose any custom duties on electronic transmissions, but that does not specifically cover any internal taxes they might charge on those electronic transmissions. And that has again raised a lot of tax related concerns, especially since government started implementing these digital taxes. Not just Canada, there have been a lot of governments, and the US government has taken very strong stance on that, and they have been constantly reporting it as a trade barrier. So I'm 100% with you that it should be a component, and hopefully you will be the future that adds that next foundation to the discussion of the digital economy.
Yeah, and by the way, the WTO digital trade moratorium is one of the few binding legal tools that we have that specifically mention, taxation and digital trade at the moment. So I think is an extremely relevant topic to cover, and this is something we leave for you guys to delve into in the future. So again, please join me in thanking Neha Mishra for today's conversation. We're very thankful.